So I think it's worth us getting started at this point. So thank you so much for joining us today for the first presentation in our joint series between the financial services regulatory teams and employment teams here at Burness Paull. So by way of an overview of what you can expect in the coming weeks, these webinars are aimed at HR professionals, in-house lawyers, and others immersed in the financial sector. We'll provide a high-level overview of the senior managers and certification regime and consider some of the employment law and regulatory implications at various points in the employee life cycle. So for those of you who don't know me, my name is Lorna Stephen, and I'm an associate in the Financial Services Regulatory team, and I'm joined today by Jamie Meachin, Senior Associate in the Employment team. And today we're starting at the beginning of the employee life cycle, and this session will provide an outline of considerations when hiring employees, including an overview of SM&CR and the steps to be undertaken prior to onboarding a new senior manager to a financial services business. So as always, just a little bit of housekeeping before we get into the swing of things. Please keep your cameras and microphones off during the presentation. We might not have time for questions during the presentation today, but our contact details are on the final slide. So please do get in touch if there's anything you would like to discuss. And finally, we will be recording today's session and it will be distributed following the presentation. So drilling down into the specific topics that we're going to cover today, Jamie is going to give an overview of the general employment law considerations when recruiting an employee. I'll then give a brief overview of the senior managers and certification regime as it applies to regulated businesses. And then we'll finish up by looking at some things to think about when making the job offer. So I'll now hand over to Jamie, who will take us through the general employment considerations when looking to onboard a new employee.
Thanks, Lorna, and good morning, everyone. So just starting with the general employment considerations then, there are a number of different things to think about when employing people in the financial services sector, just as you would in any other sector, really. So these are the more kind of general things that I'm going to cover off first. We don't have time to go into this part of the presentation in any particular detail, but so it's really just to flag some of those considerations to always bear in mind when you are recruiting staff. And the first thing to think about is the Equality Act 2010, which I'm sure some of you on the call today will be familiar with. And essentially, this piece of legislation makes discrimination and harassment unlawful in relation to 9 protected characteristics. Those 9 protected characteristics are age, disability, gender reassignment, marriage and civil partnership, pregnancy and maternity, race, religion or belief, sex, and sexual orientation. And the Equality Act 2010 and these protected characteristics will apply during the recruitment process. So always worth bearing in mind, whether that's when you're pulling together the job spec or the job advert, reviewing CVs, conducting interviews, right through to ultimately making the decision who to hire and who not to hire. Think also about data protection. Job applicants are data subjects and provide personal data and frequently also special category data to employers who, as controllers, process that data. Recruitment processes therefore raise several questions about the operation of data protection legislation. So how does the employer deal with the personal data it receives from job applicants? How does the employer conduct equal opportunities monitoring, if at all, as part of the recruitment process? And then at the end of the recruitment exercise, what does the employer do with the information it has received, which will typically vary depending on whether you ultimately hire the person or not. But how long do you hold on to that data and why? And then just finally, before we move on to the financial services specific considerations, worth also flagging that employers should always ensure that they document the recruitment process so that there's a paper trail in the event of any complaint or litigation. It should be remembered that these documents, which should reflect the decision-making process in relation to the particular applicant, may be disclosed in any tribunal proceedings and potentially also with data subject access requests as well. So your decision-making process should be written clearly and objectively. The EHRC code suggests that every selection decision, so from shortlisting through to appointment, is equally important, And they recommend that employers should keep records that will allow them to justify each decision along that process, and also to document the process by which the decision was reached. And again, these records should also demonstrate that a selection decision was based on objective evidence of the candidate's ability to do the job and meet the relevant job and person specifications, and not on assumptions or prejudices about the capabilities of certain groups of people sharing protected characteristics. So again, going back to that Equality Act point I mentioned earlier, but it's about making sure that you've got your paper trail to justify your decisions as well. So those are just kind of three of the main general considerations which I always tell clients to keep in mind, but I'll now pass you over to Lorna to look at some of the FS specific considerations.
Thanks, Jamie. So I mentioned the Senior Managers and Certification Regime, or SM&CR for short, at the beginning of this presentation, but what exactly is it? Well, it was introduced to improve accountability within the financial services sector. SM&CR is now very much bedded into the financial services ecosystem, having been introduced for banks, building societies, and credit unions in 2016, and extended to cover most other solo regulated FCA firms at the end of 2019. It aimed to improve governance and establish clear accountability for decision-making among senior managers within regulated firms, ensuring a high level of conduct at all levels of an organisation. So what did it aim to do? Well, SM&CR has three key aims. The first one is to encourage staff to take personal responsibility for their actions. The second was to improve conduct at all levels of the organisation. And the third point was to make sure that firms and staff clearly understand and can show who does what within the organisation at any time. And kind of beneath those key aims, there's three core aspects of SM&CR. The first portion is the Senior Managers Regime. So this focuses on the most senior individuals within an organisation who carry out significant roles, and requires that they be approved by the FCA or the PRA in advance of carrying out any regulated functions. Senior managers must have a statement of responsibilities and an allocation of prescribed responsibilities, ensuring clear accountability for critical aspects of the firm's operations, which we'll come on to in more detail later in the presentation. And the second part of the regime is the certification regime. So this part focuses on individuals who aren't senior managers, but nonetheless can significantly impact a regulated firm or its customers. So employees subject to the certification regime don't need pre-approval in advance of taking on the roles, but they must be certified annually by their firm as fit and proper to carry out their duties. And the third part of the regime is conduct rules. So these apply to almost all staff within a regulated business, and they're split into two layers. You have the individual conduct rules, which apply to all employees to whom SM&CR is relevant. And then you've got the senior manager conduct rules, which apply specifically just to senior managers. Now, as the senior managers regime is the most onerous part of the kind of three tiers here, I'll focus specifically on those requirements for the rest of the presentation. So before becoming a senior manager, a firm must make an application to the relevant regulator for approval. Once approved, the employee will be able to carry out certain activities known as controlled functions for the firm. I've added a definition of what a senior management function is under the Act on the slide. However, applying for an SMF approval is a significant undertaking, with applicants required to provide 10 years employment history with no gaps greater than 1 month and reasons for leaving any previous employment, residential address history of a minimum of 3 years, the nature of arrangements between the candidate and the firm, details of the senior manager function being applied for, evidence of criminal record checks, and the regulatory references, which we'll come back to talk about later. A significant process, and the regulators at the moment are really diving into the content of these applications. So it's not usually a particularly quick process to have someone approved as an SMF, and there is likely to be quite a lot of back and forth with the regulators before they'll provide their approval. So both the FCA and PRA have designated senior management functions and prescribed responsibilities that reflect that particular regulator's statutory objectives. The definition of each SMF contains a responsibility that is inherent, inseparable from, and intrinsically built into the specific role. The senior manager functions are numbered, and I won't go through them all here, but they're set out in the format of SMF and then the number. So you'll see on the slide, we've got SMF 17, which is the money laundering reporting officer, and a number of other functions there. So once the senior manager has been allotted their specific SMF responsibility, the regulated firm must then prepare a statement of responsibilities, which sets out the function and any other prescribed responsibilities of the senior manager. Details of the responsibilities will have already been provided under the initial application to the regulators, but the statement of responsibilities is a living, breathing document during the senior manager's time at the firm. So the purpose of the statement of responsibilities is to ensure that both the senior manager and the firm understand and can articulate the responsibilities which apply to each senior manager in the organisation. Generally, each prescribed responsibility should be given to the most senior person responsible for that activity or area. They should have sufficient authority and a level of competency to be able to carry out the responsibility effectively. Firms must also ensure that they understand who has responsibility for all of the different functions and activities that the firm conducts. In practice, this involves identifying the individuals who hold SMFs and assigning prescribed responsibilities to senior managers who are most closely linked to that area, and considering what other activities or areas of the firm exist that may be the responsibility of individuals who report directly to the board but are not members of the board or firm's wider governing body. So responsibilities can, in theory, be allocated to more than one senior manager, although it's strongly advised that they're only allocated to one. However, where a firm does have more than one person assigned to responsibility, each of those individuals will be deemed fully accountable in their own right. When deciding how to allocate prescribed responsibilities, firms should avoid assigning such a wide range of responsibilities to a particular SMF that they are not able to carry out those responsibilities effectively. And I mentioned earlier, there's a third part of SM&CR, and that's the conduct rules. So on the left-hand side of the slide, we've got the individual conduct rules, which apply to almost all employees at regulated firms, including the senior managers. We'll not go into too much detail on these today, but these are basic standards which apply to all employees carrying out a financial services role within the business. And these include points like acting with integrity and with due skill, care and diligence, paying regard to the interests of customers, acting in good faith towards customers as well. And these individual conduct rules also tie in with firms' overall obligations to regulators, such as Principle 11, which is dealing with the regulators in an open and cooperative way. So those are the kind of general rules that apply to almost all employees in financial services business. But then you've got the senior manager conduct rules, which sit on top of this. So these are only ones for persons who hold senior manager functions, and these are a bit more onerous. So you've got that they must take reasonable steps to ensure that the business of the firm for which they're responsible is controlled effectively. They must ensure that the business of the firm for which they're responsible complies with the relevant requirements and standards of the regulatory system. Any delegation of responsibilities is to an appropriate person, and that is overseen in an appropriate manner. And that they disclose appropriately any information which the regulators might reasonably expect notice. And there's a requirement that the senior manager is aware of these rules, and from an employment perspective, it can often be helpful to include them as a schedule to any employment or services contract in place with the senior manager, just so that they're there and so that they're clear. So now we've kind of explored the overall SM&CR regime at a very high level. It's worth drilling down into some of the finer details. So as part of the application for approval as a senior manager, the firm making the application must satisfy itself that the candidate is fit and proper to carry out the role. But what makes someone fit and proper? So the requirements around fitness and propriety are set out in the fit and proper test for employees and senior personnel part of the FCA handbook, which is often just shortened to FIT because that's much less of a mouthful than that was. The main elements to be considered when assessing fitness and propriety are honesty, integrity and reputation, competence and capability, and financial soundness. Following the application stage, so when you apply to the regulators for approval to act as an SMF, regulated firms are required to ensure that all senior managers are fit and proper on an ongoing basis, which must include an annual assessment of that. Where a regulated firm is looking to employ a new employee for a senior manager role, so during the application phase, the firm should be in a position to evidence how it has satisfied itself that the candidate is fit and proper prior to any application being made to the regulators. In addition to this, the FCA or PRA will also assess the candidate's fitness and propriety, and this goes back to the regulators really looking to understand the detail of what's being kind of put forward in any application for an SMF function. So they will be really interested in whatever evidence you have that you have satisfied yourself that this person is fit and proper to carry out the role. And we'll also touch back on fitness and propriety in more detail in a later session within this series. So next, as part of the assessment of a potential senior manager's fitness and propriety, firms must also seek regulatory references from the senior manager's previous employers going back 6 years. So there's a prescribed form for both the request being made to the previous employers and the response which would be given from any of those previous employers. And the firm giving the response is required to do so as soon as reasonably practicable, but in any event within 6 weeks. Regulatory references go beyond a mere factual reference and include quite challenging questions on whether you've concluded that the individual was not fit and proper at any point to perform the function, whether there is any disciplinary action or has been any disciplinary action which is relevant to a breach of the conduct rules which we mentioned earlier, or generally whether the individual is fit and proper. And then a third very open question about whether you're aware of any other information that you reasonably consider relevant to your assessment of whether the individual is fit and proper. So that is very wide, and it can be challenging to consider what information is, reasonably considered to be relevant, whilst filling this part of the form out. So it's very subjective, and you have to make a choice as to what you want to disclose at that point. We will go on to discuss this again later in the presentation series, so make sure you sign up for that one too. And one final point on senior managers regime before we move on is that as part of the application being made to the regulators, firms must undertake criminal records checks in order to assess the fitness and propriety of the candidate. So this will be through the relevant government executive agency where the candidate has been employed in the UK. However, if they've spent time living and or working abroad, firms should also undertake criminal records checks in the relevant jurisdictions. This only requires to be done once as part of the application to become an SMF. So it's not part of the kind of annual ongoing fitness and propriety checks. But firms could choose to refresh the criminal records checks if they thought that was beneficial. So I'll now hand you back to Jamie to discuss making the employment offers subject to conditions.
Thanks, Lorna. So I suppose when you get to the point where, as the employer, you've decided on your preferred candidate, you will quite often want to make a formal offer of employment to that candidate. And importantly, at that stage, the employer should consider whether the offer needs to contain any conditions, which often it will, particularly in this sector. And any such conditions must be made clear to the employee or the candidate. And if any conditions are not expressed sufficiently clearly, then the employer may not be able to rely on them to get out of the employment contract if one or more of the conditions are not later satisfied. So it is quite important that the employer or the prospective employer gets this bit of the process right. And any such conditions are usually included in the offer letter. And on the slide here, we've got some of the conditions which you might want to apply when you're making a job offer. in this sector. So you will want to think about receipt of references which are satisfactory to the employer. And that will include in this sector regulatory references as well. Confirmation that the employee is free to work in the UK or has the appropriate immigration approval to work in the UK. Receipt of a medical report or a completed medical questionnaire, which is satisfactory to the employer. That one's perhaps less common in this sector, I would say. You'll also want to think about whether you need confirmation that the employee holds qualifications that they claim to have, that they are free from any restrictions from previous employment that would prevent them from starting work as proposed by the employer, and also where they're to hold office as, for example, a director. You would also want confirmation that they're not subject to any restrictions that would prevent them from doing so. Something else to think about is getting background checks, which might be required professionally and will always be required in this sector, or it might be that they're due. You need these checks because of the nature of the job that's being offered. And then again, whether there's any qualifications specifically required for the job, you might want to make that a condition of the offer as well, that you see those qualifications before the person starts. And Lorna's mentioned some of the approvals that will be required from the regulator as well in this sector. So it might be that the person can't start working for you until they obtain those approvals for the regulator, or at least that they need to carry out another role in the business until such time as the approval is obtained. So you'll want to give some thought to what will happen in those scenarios, what will happen if approval is not obtained, and the person might have already started working for you, for example, or what if it's not obtained within a certain period. And again, you'll want to make sure that you're making that really clear in the offer letter and or the employment contract. So it might be, for example, that you're employing someone in a regulated role and they will be on quite a lengthy notice period, say 3 months, 6 months, something like that. But you might want to include provision for a shorter notice period in the event that they don't obtain the necessary approvals needed to carry out the role that ultimately you want them to do. In terms of the actual employment contract, if you like, there are certain requirements in terms of what you need to confirm to employees and workers now actually as well in the UK to ensure compliance with the Employment Rights Act 1996. And as well as those minimum particulars, there's also certain additional clauses that we typically recommend are included in employment contracts in the financial services sector too. Again, I don't propose to go into that in any particular detail today, just conscious of time, but please do get in touch with us after today if you'd like to know any more about that. Happy to look at existing templates or provide templates which include the kind of minimum requirements to ensure that you're complying with not only employment law, but the financial services regulatory regime in the UK as well. And with that, I will pass you back to Lorna to wrap up today's webinar.
Thanks very much, Jamie. So to wrap up today's presentation, we're just going to go through the key considerations when looking to onboard new employees to a regulated business. So at the top here, we've got, don't forget about general employment law considerations. So whilst we've got a heavy focus on the financial services aspects, it's really important to remember the basics and those points that Jamie talked about at the beginning of the presentation. They are impervious to all job offers, including in the financial services space. And then the next point is, does the individual fall within SM&CR? If so, it's going to trigger quite a lot of extra requirements that you're going to have to deal with prior to the employee taking up the new responsibilities under the new role. And that includes seeking regulatory references from previous employers, carrying out the fitness and propriety assessment, applying to the regulators for approval in advance of the person carrying out the role, and undertaking criminal records checks as well. So it really does make that more onerous than just onboarding a standard employee for a traditional role. And then the final point is that you should consider whether there are any conditions which should be put on the job offer, which, as Jamie says, can be really important, particularly in terms of the sequencing of events where you're applying to a third party for approval for acting in that role, that kind of needs to be built in. And what happens if that approval is not forthcoming, or just generally kind of thinking through the scenarios and making sure that those are accounted for in the job offer, to protect yourselves and protect everyone, and so everyone understands the terms of the contract there. So that's all that we are going to cover today. We'll be back at the same time next week talking about considerations for regulated businesses during the employee's time with the company, and fitness and propriety requirements in more detail. So please do sign up for that if you haven't already done so. We are 4 minutes early, so I'll give you 4 minutes of your day back. I'm sure you'll be delighted, but I hope everyone enjoys the rest of their day. Thanks very much.